if you don't hear back by tomorrow, just type it in Word and I'll figure it out. But my preference would be to actually use the software to figure out how to use it. But otherwise, we'll survive. Okay. All right, I'm going to turn on the attendance thing to check in. Okay. Start class. Okay. Be able to sign in now. All right. Okay. All right, ready to start. Okay, doke. Did you put your papers in on time? Oh no, you don't have to. Yeah, extension.
I
right?
walked him through this afternoon.
Okay, good. Glad you got it in. So you don't have to waste a 5-hour trip for nothing.
No, I for some reason I thought today was the 20th and yesterday was the 19th. So.
Ah. Okay. Very good. Let's see. Okay. Any questions? Anything in your minds? All right. Our topic today continues our discussion of the 14th Amendment, and particularly move on to two important provisions. The first of which is Section 5 of the 14th Amendment, and the second is the Equal Protection Clause. Today, in courts, the 14th Amendment is primarily viewed as something for the judiciary, that the court gets to decide when a state law violates the Constitution. That wasn't how it was originally designed. It's not entirely clear what role the framers had for the courts in all of this. Generally, the courts weren't involved in reviewing state legislation. The primary understanding of the 14th Amendment was that Congress would take the lead in enforcing civil rights. We already saw that with the Civil Rights Act of 1866, which was passed before the 14th Amendment was ratified. And that ensured that states could not deprive the freedmen of certain fundamental rights. After the 14th Amendment, Congress enacted other civil rights laws. These are often called enforcement acts or enforcement legislation. And the purpose of these laws was to ensure that states were not depriving people of their rights. Now, the reason why the enforcement legislation is important is it had a judicial component to it. Right? The 14th Amendment by itself didn't, but the enforcement legislation did. So we have two cases today involving enforcement legislation. We have Strouder and we have civil rights cases. And the first case involves an effort to ensure that people are getting fair trials. And if a fair trial is not to be had, then that case can be removed to federal court. Now, you may take this for granted. When you cite CivPro, did you ever think about removal from this context? About why it might be necessary to remove a case from state court to federal court? You probably only considered, well, you get a more fair forum if you're an out-of-state defendant, right? If there's diversity and you want a more fair forum. I bet you never considered what happens if you were being tried by a racially segregated jury. But I want you to think about this issue from another perspective. What exactly is removal, right? How is it that the federal government can tell a state court, you no longer have control of this case? This is an offense that happened in your jurisdiction and one that violated your laws. But we are taking away this case from you. Just think about it for a minute. That's a pretty significant claim, right? We talk about commandeering, for example, right? Where you can, you can't tell a state legislature what to legislate. And you can't tell a state executive branch official how to execute the laws. But here we have something very different. We're telling the state courts, you are now divested of jurisdiction. Have a nice day. And that's a significant undertaking, right? So we always ask the question, what gives Congress the power to intrude upon the state's courts like this? And of course, we know the answer here is Section 5 of the 14th Amendment. But that doesn't resolve the question entirely. Congress only have that power if Section 5 is a appropriate piece of legislation, right? Section 5 says Congress shall have the power to enact appropriate legislation. And what determines if this legislation is appropriate? Let's go back up to Section 1 and ask ourselves, has the state denied someone the equal protection of the laws? And if the state has denied someone the equal protection of the laws, then Congress can then step in to remedy that violation. Think of Bernie v. Flores, right? Congress can't enact substantive legislation, but they can remedy violations of the law. So the case in Strouder was not about whether West Virginia's segregation law violated the 14th Amendment. That's the quiz for today, right? The case wasn't someone saying, we think that West Virginia's law is unconstitutional. The question is whether West Virginia denied Strouder the equal protection of the laws. And if so, then Congress can then enact this Section 5 legislation to remove the case to federal court, right? This is a powers case. Does Congress have the power to do something? But you will see often that the question of does Congress have this power bleeds into the question of whether they have protection of civil rights. This case is not in your book for a reason. Most case books either don't have this case, or if they have it, they only have an excerpt of it. And I didn't actually understand this case till I edited it down for this book. I always thought, and I just assumed, that Strouder was about the Supreme Court saying that states violate the Constitution when they exclude people from the jury. I didn't quite appreciate that the case is almost entirely about Section 5 and whether Congress has this power. I also didn't know there was a dissent to Strouder. I always thought Strouder was a unanimous decision. But Justice Field, who we've studied a little bit, he actually wrote a dissent in a companion case, in a separate case. So your book, or at least your supplement, I gave you a PDF. The PDF now has that case edited, and the next 4th edition of the book, which, oh God, Randy will murder me, I think it's in 2021 or so, we'll have the case in the actual hardcover. All right. So questions about Strouder, just the general frame of how the enforcement acts work. I can't get a good camera angle to it. I don't know why. I keep having to futz with this thing. Let's try that. A little further back. I keep going off screen. Okay, that's a little bit better. Okay. Yeah, Audrey.
So Section 5, whenever it says by appropriate legislation, that means we just ask ourselves, has someone violated the equal protection of the laws?
Well, it could be anything in Section 1.
Anything in Section
Actually, to be precise, Sections 1 through 4. We don't really talk about Sections 2, 3, and 4, but they're there as well. So, for example, if a state deprives suffrage to people on the basis of race, Congress then has the power to reduce the number of representatives that state has, right? But we have these aspects of Section 1, right? The Citizenship Clause, the Privileges or Immunities Clause, the Due Process Clause, and the Equal Protection Clause, right? If a state violates one of these rights, then Congress can enact appropriate legislation to enforce those rights. I'll give you an example that I've given some thought. Let's just say that the right to bear arms is protected by the Privileges or Immunities Clause, which is what Justice Thomas thought, and McDonald. If that's the case, then if states are depriving citizens of their right to bear arms, then Congress can enact a law to enforce that right and ensure that people have this right to bear arms. So there's a piece of legislation floating around that would effectively guarantee a right to concealed carry nationwide. How would that work? The Congress would say that the Privileges or Immunities Clause protects the right to bear arms, then includes the right to carry. And if you can carry arms in one state, you should be able to carry arms in another states. So let's say I have my Texas concealed handgun license, I should be able to bring it to New York. Now, as an original matter, I think that legislation is probably constitutional. I think the problem is Bernie v. Flores suggests that Congress can only remedy violations of the law as the court has interpreted it. They can't make substantive interpretations of the law And the Supreme Court has not deigned to tell us the scope of the Second Amendment. So I think that legislation would probably be unconstitutional under modern doctrine. But it's anything in Section 1, not just equal protection. Make sense?
Mm-hmm.
Okay. All right, so any questions? Okay, Lindsay, let's start with the facts, please, in Strouder, which again, the facts in this case are not at all what I expected.
So Strouder had murdered his wife?
Yeah, just let me pause for a second. I always assumed in this case that the guy was getting set up, right? I just assumed there's like a To Kill a Mockingbird situation, right? Where like you had an African American guy who was being set up for murder, and and they were trying with an all-white jury to kill Mockingbird, right? That's just what I assumed because I never actually read the entire case. I went back, oh wow, and then I started digging and I found some newspaper headlines, and this was like a sensational story. Apparently, he killed with an axe or like some sort of blunt object, and it was really violent, right? Like, and it was like tabloid story for the time in West Virginia, and so this case is completely not what I thought it was going to be. And every time I was like, wow, that's not. Because I taught a case for years, and I actually finally read the entire damn opinion. It's like, wow, that's not at all what I thought. All right, go on, Lindsay. I didn't mean to interrupt you.
So he was arrested and put on trial, but at the time, West Virginia had a law that only white men could serve on juries.
And white men, not women, only white men, right?
White men.
Yeah.
So he argued that he was being denied equal civil rights and a fair trial.
Good.
And so he wanted his case removed to federal court.
Okay. Chelsea, what was the standard under the federal civil rights law to have a case removed from state court to federal court? What was the standard that the statute put forward? What did he have to show? What did Stratford demonstrate?
That he wouldn't have equal protection.
Yeah, okay. So the phrase is that the prosecution would deny rights to which was entitled in the Constitution. In other words, if the state was denying something protected by the 14th Amendment, then it can be removed. Now, generally, I actually may not know this, but generally when you want to remove a case, it works like this, right? You file a notice of removal in the state court, and that puts everything on hold. And then you file a removal motion in the federal court, at which point the federal court decides is there jurisdiction, in which case they keep it. And if there's no jurisdiction, they remand it back to the state court. But the important point is after the removal motion is filed, everything gets frozen, right? Everything gets put on hold until the removal issue can be litigated. And you probably don't know this, maybe you do. A motion to remand, if it's granted, you can't appeal that. So if you get your butt sent back to state court, you cannot appeal to the Fifth Circuit. There's a couple exceptions which I've been involved with, and it's called creative, but generally you cannot appeal a remand. But that's not what happened here, right? Mr. Strouder goes tell the state court, hey, yeah, I have an all-white jury. I'm being denied my rights in the Constitution. I want to remove it. Please put stuff on hold. And what do you think the state court says? Nope. We're going to keep on trying you. I don't actually know the answer. I don't even think the federal court ever took any action in this case. I've given this some thought, and I don't see anything in the record to reflect otherwise. But generally, when you file a removal motion, you get something from the federal court saying yes or no. As best as I can tell, and I might be wrong on this, but as best as I can tell, the state court ignored the removal motion, didn't even put the trial on hold, went ahead to convict the guy. And then it was a case appealed up to the state courts. But I don't think the federal courts even ever ruled on this. And it'd be a weird thing to have because removing the case doesn't mean he's innocent, right? This guy murdered his wife, right? There are some cases where people were set up in sham. This wasn't it. This guy was dead to right. He killed his wife, right? He did it. So all that could have then happened was that a federal trial could have been convened, right? You have a trial in a federal court with a mixed, an integrated jury. That never happened, and I don't know that the federal courts took any action on the case. Maybe they did, but I haven't been able to determine that. Okay. All right. So Strouder said remove it, and then the state court says no go. Now, the state courts, they didn't argue that the Enforcement Act was unconstitutional, right? Maybe they did. I didn't see it, but the state courts didn't say you cannot remove it because Congress lacks the power to enact this law. That wasn't the argument. Instead, the argument was that you are not being denied a right under the Constitution. In other words, the basis for the removal was not satisfied. Again, generally, it's the federal court that decides whether the removal is proper. Right? The state court's not the business of deciding if federal removal is justified. But here, it was the state court deciding in the first instance if removal was appropriate. And that's exactly the opposite of how we think it works today, right? Yeah, it's the exact opposite. And the reason why is we don't trust state courts to enforce federal law in this fashion. That's why you have the removal statute, right? The reason why Stroud wanted to get his butt out of state court was because it was a rigged jury, and it was a rigged system against him. But he wasn't able to get his day in federal court. I mean, the dude would have been convicted anyway. It doesn't really matter, but at least he could have had a fair trial. Okay. The West Virginia Supreme Court said no. You are not denied any right, and they say there's no reason why a jury of white men cannot do justice to you as would a jury full of black men. All right? So, Audrey, let me ask this question. Does Strouder have a constitutional right to a jury of his own race? Does the Constitution require a jury of your own race?
The Constitution specifically, here the court mentions that the 14th Amendment, under the Equal Protection Clause, the right to have a jury.
Okay, let me ask the question a little differently. Why would having, and there's an obvious answer, right? I want the obvious answer. Why would having an all-white jury necessarily deprive him of his rights under the Constitution?
It wouldn't be impartial.
How do you know that?
I don't know that.
You don't. You know, I clerked for 2 years in Western Pennsylvania in a small town. You know, we had a lot of jury trials. Not a lot, but we had a lot for federal court. I did not ever see a single African American walk in for jury duty, not one. All the juries were white by virtue of what's called the veneer, or vernier in Texas, right? The people actually walk into court. I do not recall a single person of color at any juncture in jury duty in the 2 years I was clerking there. Just they either never came in, or they weren't called, or they just didn't live there. I couldn't tell you, right? And I can I can tell you there were a number of black defendants, right? Now, Western Pennsylvania is not West Virginia in 1870, right? They're different worlds. But the court seems to reason from the premise that having a jury exclusively of people of the opposite race cannot render a fair verdict. And Justice Field attacks this point vigorously in his dissent. You know, I just want to throw that out there. But the court seems to start from the premise that having a jury selected in this fashion would deny the equal protection laws. But it's not self-evidently so. Because the presumption then is that people of one race might be unfair, but people of the other race might be more fair, right? Might be more objective. You'll study in criminal procedure a case called Batson versus Kentucky, B-A-T-S-O-N versus Kentucky. Very important case. This case held that when you're striking jurors, right, when you're doing jury selection, and you're removing jurors from the jury pool, you cannot do them on a racially discriminatory basis. Does that mean you cannot remove an African American juror? No, but it generally means you have to have a reason. You can't just do it arbitrarily. And then there are cases where, you know, say there are 5 black people in the jury pool, all of them are struck. The court very likely may throw the trial out and start from scratch, saying it was a biased appeal. So Strouder was sort of the precursor in some regards to Batson, the idea that if you're excluding jurors solely on the basis of race, then you're trying to shift how the jurors perceive the case in a fashion that's unfair to the defendant. Okay? So the first part of Strouder effectively held that the guarantee in the Equal Protection Clause is this: you have the right to a jury selection without discrimination on race. Now, Tyler, let me ask you a follow-up question for the one guy in this room. Could a woman who's on trial have raised a similar argument? That is, there are no women in the jury. I don't think I'll get a fair trial.
I mean, the statute still says the same thing. It says white men 21 years of age.
That's what it says. So could a woman say, I would like women who are of age to come sit on my jury?
She could, but I think it would be met with a quicker, what's the right word, repudiation than this one was, because we didn't just come through an entire gender.
So this goes back to a theme of was the Civil War fought for only the equality of the freedmen? Or also did the language equal protection for all persons, doesn't say men, doesn't say women, do we read the language more broadly? Right? At this time, I don't think any woman could serve on jury duty anywhere in the country. Right? So this would not be a West Virginia problem, this would be a problem in all the states. Or in any state, if a woman was tried for a crime, and there were women prisons, they existed. If any woman was tried for a crime, she could then assert that it's a denial of the equal protection of the laws. Now, I think here we have the governing precedent of Bradwell. Remember Myra Bradwell? The delicate sex, as Justice Bradley explained it. That their purposes in life is to basically produce children and serve in the home. I don't think that argument would go very far. But if we take seriously the notion that having a jury of all of one race is not fair to some of the opposite race, then a jury of all of one gender might be unfair to a defendant of the opposite gender. I mentioned Batson a few moments ago. That doctrine is also extended to women. So if you strike all the women on your jury, what tells in the case? I think it was JEB. What the hell? Blanking the name of the case. But there's another case about Batson challenges for women. What the hell's in the case? I'm blanking on it. Edmondson. Yeah, it was JEB versus Edmondson. That was the other case. It was JB. No, what was it? What was the other case? It was, I'm sorry, I got it wrong. Sorry, it was Edmondson versus Leesville Concrete Company. About you cannot use discriminatory challenges based on gender. No, that wasn't it. It wasn't Edmondson. I'm blanking the name. I keep thinking of JEB. I don't know why I'm thinking of JEB. Wasn't the case? I was right. It was JEB versus Alabama. Okay, I was right the first time. Yeah, JEB versus Alabama was that you cannot use strikes against people based on their gender, peremptory strikes. Okay. All right, so that was the first part of the court's holding in Strouder, that because a jury impaneled of only one race is a denial of equal protection, because the guy won't get a fair jury. Okay? So if there is in fact a violation of the Equal Protection Clause, then there's something to remedy, remedial power. And then Congress then used its Section 5 powers to enact appropriate legislation, which was the removal statute. So therefore, the removal was proper. Okay. We have a dissent from Justice Field. Again, Justice Field was one of the dissenters in Bradwell as well, but he was in the majority in Slaughterhouse. He found there was no problem with limiting the jury pool to white men. And he said because there's no violation of the 14th Amendment's Equal Protection Clause, Congress lacks the power then under Section 5 to enact legislation. Are you with me? Now, at the end of Strouder, the court doesn't say the West Virginia law is unconstitutional. That is not in the case. Which means, after this law, did West Virginia suddenly start to accept black people on the juries? No, they did not. Did every other state in the South suddenly start to accept black people? No, they did not. This is, again, I think the biggest misconception about the state. All Strouder held was that in this case, removal was appropriate. Right? That's it. It didn't affect any future trials in Alabama. I'm sorry, not Alabama, West Virginia. All right. Questions about Strouder? Yeah.
So it doesn't, I thought this was relatively simple, like more procedural than substantive. Why was there, I thought that was a lot of what Article 3, Section 2, with this vested power of the judiciary, they make specific reference to criminal prosecutions being tried at the federal level and the Supreme Court having appellate jurisdiction.
Good.
Why on the face was this removal clause at the state level not unconstitutional?
I'm sorry, say your question again? I lost you in the last sentence.
If there was a federal rule of civil procedure. Right?
Okay. So the Constitution does speak of jury trials of criminal matters, right?
Right.
But those are federal prosecutions. This was a state prosecution, right? Mr. Strouder was not convicted of violating the law of the United States, right? The murder statute was not arising under the United States. This was a state statute. There was no reason why this federal crime should be, this state crime should be in federal court. I think we touched on this in the last class. Murder is not a federal crime, right? Murder is a state law. And generally the only place you can prosecute murder is in state court. Unless this removal statute operates to remove it, right? Because you're saying there's a violation of civil rights, which gives the federal courts jurisdiction. Right? Generally, federal courts, you cannot prosecute a state crime in a federal court, except with this removal power, which the court said was appropriate here.
So when did the earliest I could find was 1956, and so it would have had to be way earlier.
Earliest what you could find?
Criminal procedure codifying how to remove something from state court to the federal level.
What happened in 1956?
That was 1455 removal process for a criminal prosecution.
What about the Civil Rights Act in this case? I mean, that was earlier. That was 1880 something.
Right, but as far as how to do it, what did the federal government have?
Oh, you asked me. So after,
governing the process?
so I mean, after Strouder, what happened? I think they vacated the conviction. I think that's the primary effect. I don't know if he was tried in federal court. I doubt he was. I'll check that later. I don't know what happened to him. Now the question I think you're also asking is, was anyone else post Strouder relying on the statute to move their case? I mean, I don't know. It's a good question. I'm sure there was some process. What I suspect would happen is that the West Virginia district attorney, the prosecutor, would refuse to even step foot in the federal courthouse. I don't think he would even consider impaneling a jury with African Americans. I think he just wouldn't even do it. So as a practical matter, the removal may have basically amounted to an acquittal. Right? The removal may have basically made it impossible for the prosecution to go forward. Maybe they did. I don't know if any state prosecutors actually took up the government and went ahead and tried the case in federal court. Because it's not like the federal prosecutor could step in. This is still a state prosecution. I don't know. The one in 56 you found, that was the modern removal statute?
Yes, sir. It was 28 U.S.C. 1455.
Yeah, I mean, nowadays, this happened a lot during the Civil Rights era, where you have removal of these sham trials where they would, To Kill a Mockingbird style, right? Where they basically charge a African American guy for a crime which he didn't commit, and then they'd remove it. But I don't know how much post Strouder you actually had these cases actually removed. I don't know the answer. I'll think about it later.
What about reverse? When I was reading this, and forgive me, it's like my generation, we compare everything to OJ. As I remember, that was a big deal. Is Mr. Cochran wanted one black juror. That's all he said that he needed to get a hung jury. When conversations like that are had, what evidence would the prosecution have needed to compel the opposite, like sort of challenge to his? You
need a white juror to have a fair trial. Okay, now we're getting a little bit out of my depth, but I'll do the best I can. These are very these are difficult topics because they're based on stereotypes, right? You're not lawyers yet, but you'll be a lawyer at some point. And if you do trial law, you're going to have to do jury selection. And when you're running jury selection, invariably, you have a very short time to make judgments on whether a person will help or hurt your case, right? You know very little about them. You know their occupation, you know maybe their age, where they live, you know their race, you know their gender, and then you know whatever information they might tell you during the voir dire, or in Texas voir dire. You are invariably making, you know, judgments about them. So I'll give you an example. I was recently called for jury duty. The facts of the case, I found out later, was you had an off-duty Harris County police officer who was working private security. And he basically assaulted a guy in his job with some sort of blunt object. He hurt the guy very badly. Now, it wasn't clear if the assault was actually part of his duties, but he hurt the guy. And then the prosecutor decided to charge him with a crime. Right? This wasn't a civil action. It was a prosecutor charging him with basically aggravated assault and battery for assaulting this guy. Now, I knew within 3 seconds I was getting bounced because I wrote down on my jury form, law professor. I'm like, oh, there's no way to let me a jury. So it was even worse. During the jury selection, one of the lawyers said, Professor Blackman, tell us, what's in the Fifth Amendment? I'm like, oh, God. I'm like, there's a lot of things in there. He's like, no, what's in there? I'm like, due process clause? Like, no, the self-incrimination clause. Oh, I'm sorry, I didn't know. But there was no way they were laying me on the jury. Why? Because I could have controlled that jury the same way I'm controlling. No, but the same way I'm teaching the four of you about law, I could have owned that jury. It would have been so simple for me to do it, right? I could, whatever question they ask, oh no, here's what the law is here. And I'll just tell them. So I got bounced. Right? But they also are asking questions like, you know, what's your opinion of law enforcement, right? You know, how do you perceive law enforcement? And there were some people who said, you know, in my neighborhood, law enforcement's not very well liked, or when I see a police car, I get scared, or when a cop rolls up, I don't want to get I don't get shot. And again, the defense attorneys were looking for people who would be supportive of law enforcement. So you balance, you strike the jurors who are skeptical of law enforcement, okay? Now what happens if all the people say that are all black? You might have a Batson challenge. So this is a very, delicate, sensitive issue that I don't think I can even remotely do justice to, other than to leave in your mind that the jury selection process is extremely difficult. But it is based on stereotypes that some people will be better for your client, and other people will be worse for your client. But you are now restricted in how you exercise your challenges because if there's later viewed to be a racial element. Now, there's some cases where it's egregious, right? There was one case at the Supreme Court recently where the prosecutor had a list of the jurors. He basically put a check next to all the black people and struck all of them, right? It was like so, it was so brazenly obvious, and he did this in a lot of different cases. Right? It was just, it was an initial something, some sort of a symbol he would just put next to all the black jurors, like strike, 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 right? So there's some cases where it's really freaking obvious what's going on. The other case where it's a lot more subtle. I know I didn't answer your question, but you can mull it over for a little bit.
No, you absolutely did.
Good. But yeah, the second I was like, there's no way they're picking me. And he kept saying, Professor Blackman, do this. I'm like, oh, stop calling him. Because here's the problem, right? When you are the juror, your job is to find a fact. That's your job. The judge assigns the law, and then you're the jury, you find fact. They were all asking me legal questions, and I was like, I'm not going to answer your question. So even something as mundane, we were sitting in the hallway waiting for them to call us back in, and they didn't tell us why we were waiting, but I knew they were doing strikes. And one of the people said, what are they doing there? I'm like, oh, I don't know what they're doing. Because I didn't want to say, they're now deciding if you were either a peremptory strike or a strike for cause. Because that would then give them an impact of, well, I wasn't struck for cause, that's good, right? Even like little things, like I could have just hung that jury if I want to so easily. I probably nullified it as well. The statute shouldn't even apply because this person was off. I could have done whatever I wanted, and there's a good reason why they struck me. I think there was one other lawyer sitting on the other side of the court who was like, yeah, I think it was like a tax lawyer. Like, I'm a lawyer, but I hate the cops. He said that, I hate the cops. And he may be trying to get out of jury duty, I don't know. Or maybe he was honest, but a lot of people are like, yeah, I don't like cops and I don't trust them. And when I see cops, I'm afraid of them. And I don't want in my community, when a cop rolls up, it's usually for no good. And that's a completely valid, rational thought, 100% rational. And then if you're the attorney, you're the DA, you're like, I want that person because you're going after the cop. And then if you're the defense lawyer representing the off-duty cop, you're like, I do not want that person on my jury. And you have to balance how many strikes you have. Yeah, I would have liked to have been selected, but I knew there was no way for that case they were going to pick me. There's no way they were laying me on that jury. I think they even Googled me. They knew stuff about me. Press, you write about constitutional law, don't you? Don't call me. Stop calling on me.
Have you ever been on the jury?
Never. I never got it. That's the furthest I've ever gotten. I got called a couple times. Oh, God. Once. Oh, my God. Once. This was funny. I called for, I think it was county court or something. And the judge was asking some questions, just to see people going. And they asked some questions of like, he was asking about some founding fathers, trying to impress people, and he got the wrong one. And then, like, I told him after, it was actually George Mason. He's like, how'd you know them? I waited till afterwards. I didn't tell him during. But, like, he's like, I've been doing this for 15 years. No one's ever told me I was wrong. I was like, I'm sorry. But the case settled out, so I didn't get picked. Have you ever did jury duty? You ever do it?
No, that's what I was going to ask. When do the attorneys see the person or see the name?
So the way it usually works is like this. You get there first thing in the morning, and you fill out a form. And the form asks for your name, your address, your occupation, your race, and some other piece of information. And then they put all these forms in this huge pile, and they sort of divide you up in different pools for different cases. And then the lawyers have maybe 30 minutes or an hour to review the papers. And everyone has a number. And at that point, each side can basically take 30 minutes or however much time they have to present the case, just the overview of the case, and ask about people if any are conflicts. So they'll say, raise your hand if this and raise your hand if that. How many people, do you know any of the parties in this case? And they'll strike you right away. Then they'll start asking questions one at a time to some people. If someone says, I really don't like cops, then they'll probably go and ask some questions particularly. And then they excuse everyone to the hallway, and they exercise their strikes. There are two types of strikes. You can strike for cause. For example, if the witness knows the defendant or knows one of the lawyers, you probably have to strike it. And there's a peremptory challenge, which means you don't need a reason at all. You just say you're gone. And those are the challenges that can't be exercised in a racial fashion. But yeah, I wasn't getting picked. I mean, it was a long day. I was there for almost 7 or 8 hours, and I mean that's quick for jury selection. It's actually not very long. That's quick. In the federal system, you can take a couple days to get a jury. It sometimes takes a while. State court's usually quicker. Yeah, it was a long day. All right. Any other questions on this? So I was just finishing up Strouder. Let me summarize a little bit. Strouder was an important case because it was rare that the court actually upheld an exercise of Congress's Section 5 powers. It was one of the rare cases before the Supreme Court where they actually ruled in favor of the Reconstruction powers, and that was in 1880. 3 years later, we have civil rights cases in 1883, and that case took a very, very different direction. The removal of power was fairly narrow, right? It only affected a small subset of cases where the person actually wanted to take the case from state court to federal court. The civil rights cases involved a much more significant law called the Civil Rights Act of 1875. And this was the most widest ranging, furthest reaching civil rights statute on the books. And this was basically the high watermark, right? After 1875, the southern states started to gain more representation in Congress, and Congress started to back off actually enforcing and enacting new laws. That became not a priority. So the civil rights cases were like the last effort by the executive branch to enforce the laws in the books. And it didn't exactly work out. All right, so I think Lindsay, you're next. Lindsay, tell me, what did the Civil Rights Act of 75 accomplish? What was like the purpose of this law? It did a lot of things, but in particular, what did it accomplish?
It stated that all persons within the jurisdiction of the United States should be entitled to the full and equal enjoyment of accommodations, advantages, facilities, public conveyances, theaters, other places of public amusement, and applicable to citizens of every race and color.
Okay,
So
very
it
good.
was supposed to stop like common carriers and other places from discriminating.
Very good, very good. Okay, actually, the registrar just emailed me back. Let me respond. I think they forgot. Please confirm. Are all of you planning to type? Do we need blue books? No. Okay, good. I sent this information weeks ago. Please use separate exam numbers for the midterm. No Scantrons or blue books needed. Thank you. Okay, they forgot. It's okay. It's the summer. I think in the summer one takes sort of the time off. Okay. Thank you so much, Lindsay. That was exactly correct. We have the Civil Rights Act of 1875. And the purpose of this law was to stop segregation in places of public accommodation on the basis of race. Now, we often think of segregation as something that only private businesses can do. But the essence of Jim Crow, what Jim Crow was defined by, was a total and complete systemic form of segregation. You had private businesses and you had government enforcement in terms of facilities, trains, railroads, schools, etc. It was from top to bottom. The Civil Rights Act of 75 was trying to stop certain types of businesses, not all businesses, but certain types of businesses from denying accommodations on the basis of race, regardless of condition of servitude. And these businesses were often what were called common carriers. You probably say this maybe in torts or contracts, right? And a common carrier was somewhat unique. These were businesses that were given a monopoly power. So if you were a railroad, right, the government says, we don't want 25 different railroads going through our town. We will allow one railroad. And as a monopoly, you have that one railroad. No one else can compete with you. But because we're giving this monopoly, you're required to take all customers who pay your rate. And this was the basis for states establishing rates of railroads and the like. But even long before railroads, you had restaurants, you had inns. And the general idea was if you ran a hotel or an inn, as they were called, you had to take all guests who could pay your fee. Like Jesus, you can't make them sleep in the barn, right? You have to take everybody. If you ran a restaurant and someone was coming by on the road and they were hungry and they had money for you to pay whatever the fee was for your restaurant, you had to treat them. If you had a ferry system, right? Someone needs to cross the water, there's only one way to get there. You were required to accommodate them if they paid your fee. The places of amusement part, though, is a little bit trickier, and Harlan sort of dabbles on this. But places of amusement traditionally were not considered common carriers, right? You didn't have a right to go to a movie, no movies, but an opera or a theater or something. But at least for most of the facilities in the Civil Rights Act, these were common carriers with monopoly power. This fact is important because under the common law, they couldn't exclude people. Yet we have situations where they were excluding people from these facilities. All right, everyone with me? All right. It's really Lindsay, Chelsea, and Audrey. All of your names ended like an E sound. It just occurred to me. And, well, no, your name doesn't, but close enough. Okay. You have a Y in there somewhere. Chelsea, you want to give me the facts, please, in the civil rights cases?
Yeah. So this was multiple cases all together.
Yeah.
And they were indictments for denying accommodations and privileges of an inn or hotel, denying them privileges and accommodations of a theater, and refusing a person a seat in the dress circle of a theater in San Francisco.
Okay, very good. Okay. Okay. So let's talk about the facts here, right? So the first part I always like to stress is segregation was not a Southern enterprise. It wasn't like, everything, all the Confederate States of America had this and the other states didn't. This was nationwide. It truly was. We have theaters in San Francisco. You have theaters in New York, places which you generally don't associate with segregation. It was everywhere, right? It was a systemic problem nationwide. The second thing I like to stress about this case is these suits were not brought by patrons who were excluded, right? This wasn't the case that you had someone like Homer Plessy, right, who was denied entry to a train car, right? It wasn't the person who was denied entry to the facility bringing the lawsuit. Instead, who brought these lawsuits? The United States, right? Federal United States attorneys charged with crimes. Right? These were criminal matters. They indicted the owners of businesses. They weren't seeking to fine them. They were trying to throw these guys in jail, right? And that's how serious the Civil Rights Acts were. This was trying to use the power of the United States federal criminal system to throw in jail those who segregated their establishments. Okay? Now, in every case, they were indicted, and those indictments were challenged, right? If any of you ever get indicted, hope you don't, but the first thing you do is you challenge the indictment of saying that the statute which you were charged with violating was unconstitutional. If the Civil Rights Act of '75 was unconstitutional, then the indictment has to be dismissed, right? You cannot be prosecuted and tried for violating an unconstitutional law. If the law is unconstitutional, the charges go away. So the threshold question is not, did these people actually segregate? Oh, they did. There's no question they did. They did it. But the question is the legislation constitutional? Okay, so this case comes to the Supreme Court about 8 years after the Civil Rights Act was passed. And all the defendants moved to dismiss the indictment. We have the majority opinion, right? Justice Bradley wrote a majority opinion. The court split 8-1, was not even close. And the court found that this major piece of legislation enacted years after the Civil War concluded was unconstitutional, right? Slaughterhouse was sort of a problematic case because it was the first case to interpret the 14th Amendment by itself. But there you had butchers making these wild claims about liberty of contract. But here, you have a statute enacted by the very Congress that enacted the 14th Amendment some years later. And they put the statute forward. They say, we want to end segregation. And what does the Supreme Court say? No, you cannot do that. You can't do that. It's unconstitutional. All right, so Audrey, there are two major provisions of the law, or two amendments that are relevant here. Right? What are the two amendments that are relevant here to discuss?
14th Amendment with the equal protection clause inside that.
Okay, and what's the other one?
I don't know.
Well, Harlan talks about it.
Would it be? No, I don't know the other one.
Tyler? What's the other amendment that's relevant here?
Well, there's one he talks about a lot, and there's one I think he should talk about a lot more. 13.
That's what I'm thinking of.
Commerce.
Well, they don't talk about commerce at all, do they?
He should.
Why should he?
Because it's like exactly what they did in Heart of Atlanta. Like reading that case first, it seems clear that's the way ahead, right? Givens it happened, so they had some precedent.
Was this commerce between the several states?
Could have
Among
been.
the several states?
Railway. I mean, common carrier. It's innkeepers denied. I mean, it's exactly Heart of Atlanta, right? Eventually.
Right. So actually, the commerce angle, I think, is actually relevant to Plessy also. you actually had interstate railroads. Let me just pause and make this point. Civil rights cases with 1883, right? What year was Plessy? 1896, I think. Right. So about 13 years later. Let's say that the Civil Rights Act was unconstitutional in 1883, right? Because they said this is not state action, okay? In Plessy, you have a state law that says we are segregating land conveyances. The Civil Rights Act says you cannot segregate land conveyances. So the million-dollar question for all of you, why wasn't the Louisiana segregation law preempted by the Civil Rights Act of 75? There's an easy answer, but that's a much harder response. Right? So, Lindsay, you're Homer Plessy, right? You go to the Supreme Court in 1883 and say, you know what? We have a segregated train line. We have the Civil Rights Act of 75 and says you can't segregate trains. What's the response?
Isn't it that the Supreme Court stated that the Civil Rights Act of 1875 was unconstitutional if there was not a state actor, but then in a later case they said it was unconstitutional across the board, whether it was a state actor or a private actor. So it was completely invalidated. Right?
Does the courts invalidate statutes?
Well, struck down or whatever.
Do courts strike down statutes?
No.
All right, so this goes a little deep, but I think you guys are okay for it. One of my pet peeves is the phrase struck down. I try to eliminate all usages in the supplement. We still have some of the other book that I got rid of in the next edition. Courts don't have the power to actually take a scissor and cut a statute out of a book, right? Courts don't have what might be called the writ of erasure. They can't erase stuff from a statute book. All courts can say is that in a given conflict, that a statute cannot be enforced between party A and party B. This is sort of the Lincoln argument, right? So the civil rights cases, all it really said was that the statute cannot be enforced with respect to the businesses at issue, right? Theaters and various places of accommodation. The court said nothing about railroads. There were no indictments about railroads in the civil rights cases. So I've long thought, and I didn't make this up, a professor named John Mitchell, who was my professor at law school, wrote this in an article that blew my mind. The Civil Rights Act of 75 is still on the books. And it still has validity if there's state action. So in fact, if there is some sort of public conveyance that's authorized by state law, then there would be state action. And as a result, Congress would have the power under Section 5 to regulate that state action. So in every regard, the Louisiana segregation law in Plessy, which we'll study later today, did violate and did conflict with the Civil Rights Act of 75. So the court didn't need to even reach the 14th Amendment issue. Right? The court didn't need to reach the 14th Amendment issue because it was preempted. Now, what did the Supreme Court say in Plessy about this issue? No. We struck it down. Right? Yeah. And Plessy said, we struck down that law as no validity anymore. We struck it down. Nope, doesn't work like that. So here you have a case where the court went out of its way to not only say the Civil Rights Act of 75, well, let me say it without the negative. In civil rights cases, they said you need state action. But at least that leaves open the possibility that if there is state action, you run afoul of federal law. But in Plessy, said, no. We killed the law altogether, with or without state action. So effectively, you could have had a state action suit in Plessy that would have violated this law. But no, the court said we're not going to let that work. Because once we strike down law, it's gone. Courts do not have this sort of writ of erasure. I can give you lots of examples, right? let's say the Supreme Court rules that paper money is unconstitutional in the legal tender case. And then a year later, you get a couple new judges say, no, just kidding. Right? The statute about paper tender didn't go anywhere. The statute's still in the books. And now you just basically reanimate a statute that was previously declared unconstitutional.
So, are you talking about like the federal government cannot get rid of laws, or no government?
No, courts do not have the power to erase statutes. It's a controversial point. What I'm saying, people don't like it. When I tell people this, they get angry at me.
I'm asking because I read a lot of stuff at work, and like Texas has completely redone the Code of Criminal Procedure in regards to writs. And so there are sections of the statutes that are struck through. They're still in the book, but they've been repealed.
Yep, but by statute or by courts?
I'm not sure.
Probably by courts.
Okay,
That's fine.
So, okay.
I'll give, go ahead, please finish.
I was saying, the court can.
Well, I'll tell you what. So we'll study later this semester Lawrence v. Texas. Right? This was a case where the Supreme Court ruled that Texas's criminal prohibition on sodomy was unconstitutional. Mm-hmm. You can flip to the Texas Code, and it's still there, with a little notation, declared unconstitutional by the Supreme Court. It's still there. And if one day the Supreme Court reverses Lawrence, that statute will reanimate, come back to life.
Okay, so that's why they keep it in there, but
I
they
think
just
so.
strike through everything.
Exactly.
Okay.
Congress, they can erase their statutes.
So Louisiana was, that was a response to this. It's kind of like, we said that we're talking about state actors, and the state said, okay, fine, we're going to say segregation to law, and this is what it's going to look like. So it's like the collective judiciary wanted states to take this action, needed the states, I guess, to take this action so they could regulate it via this enforcement legislation.
Mm-hmm. Yeah. So because of the we didn't even discuss the case, but because of the broad ruling in civil rights cases, they basically wiped out enforcement even where there was state action. But anyway, so let's just do the two provisions of the Constitution are the 13th and 14th Amendments. We'll do the 14th Amendment first. All right, so the first part of the court's opinion, the court holds that in order for Congress to intervene, there has to be some sort of state action. And they say, look at the Constitution. The word state is in the Privileges and Immunities Clause. The word state's in the Due Process Clause. And the Equal Protection Clause also applies to states. When private businesses engage in segregation, there's no violation of the Constitution. Justice Bradley writes that civil rights are guaranteed against state aggression. Your civil rights cannot be violated by private acts of individuals. And that the 14th Amendment was intended only to deal with deprivation of rights by the states. That was the wrong to be remedied. This doctrine came to be known as the state action doctrine. And it's still good law today. In fact, when you read cases like Bernie v. Flores and others, the court reaffirmed, Morrison, it was in Morrison, the court reaffirms that only state actors can violate the Constitution. Okay? So any question on this part of the holding? All right. Justice Harlan dissented, and he argued that, in fact, common carriers were state actors, and that a common law duty not to discriminate against customers. All right, so Harlan didn't actually dispute the 14th Amendment state action doctrine. He effectively conceded it, but he found on the facts that these businesses were authorized by the state because they had monopolies. They had licenses. Now, question, does any business that gets a license become state actors? In that case, almost every business today would be a state actor. Let me ask the question differently. If the government decides to basically designate every single business a common carrier, then everyone's a state actor. Right? We have cases in the court now where you have small bakers with 1 or 2 employees who, for example, decline to bake a cake for a gay wedding, is that person then a state actor? Right? Under federal law, almost all businesses are considered places of public accommodation. Not all, but just about all. So if any business is considered a place of public accommodation, then you can see how broadly you expand the scope of Section 5. Yes, Lindsay, you seem perplexed.
Well, I just realized what you said about the bakers, that this.
Well, they violated Colorado law. They weren't violating this law.
Oh, yeah, I just noticed.
But the notion is when you broadly consider what a public accommodation is, you then sweep in a lot more people whose businesses can be regulated by the federal government.
And these days are.
So some state, most of this is actually state law, but most states have designated virtually any business a place of public accommodation.
Okay.
Indeed, if you watch the new Taylor Swift video, at the end she plugs this new Ante, the Equality Act. This law would basically designate almost every business in the United States. The video, you watch the video?
Yeah,
I didn't.
saw the very end of it.
I didn't like the video.
Yeah, I was confused.
That was too. I'm actually.
I
Oh
was
my
confused
God.
on what
Okay.
her.
Oh my God! I'm gonna have
what
the Taylor
her
Swift will come
law
after me now.
was. Or what is she trying to propose to get people to sign?
The petition support the Equality Act.
Yes, what I.
And that's what I'm talking about now. The Equality Act would make it a prohibition under federal law to discriminate against LGBT status, but would also expand the definition of public accommodations to virtually every business in the world, or in the United States at least.
And then the Supreme Court just, for the Baker case, did they just send it back to the state?
That was another Baker case from Oregon.
Oh.
The Supreme Court likes to kick things down the road. I'll be angry tomorrow, but I won't be here in class. You won't see me angry. But John Roberts will disappoint me. He will. Just somehow tomorrow. I don't know how, but he'll disappoint me. Yeah, I didn't like the Taylor Swift videos. It's too preachy. Leave me alone. Her song came up in Pandora. I hit next. I was like, no, not listening to it. Yeah. Is Pandora?
I didn't know that was still in business.
Thanks. I like it. I don't have any interest in picking songs, so I let the random go on forever. But I swipe for Taylor. No. I saw her perform years ago at Heinz Field in Pittsburgh, I think like 2010 or 11. It was like a long time ago. It's a good concert. Okay. All right, so that was Harlan. Harlan, though, kind of conceded that theaters aren't public accommodations because they require licenses to operate. They're common carriers. And if that's the test, then virtually any business that exists can be a common carrier. So this broad construction of the 14th Amendment, as Harlan construes it, would basically let Congress regulate any business at all. Okay? They did not talk about commerce, Tyler. Not a word about commerce, because there was no even inkling that a local business was engaging in interstate commerce. That wasn't even a thought. Railroads crossing state lines, perhaps. Water conveyances, perhaps, but not segregated theaters. There was no discussion of the Commerce Clause anywhere in this debate, nor the Necessary and Proper Clause. Modern civil rights laws, as you know from the Heart of Atlanta, is based entirely on basically the Commerce and Necessary and Proper Clause. Okay, so any question on the 14th Amendment part of the analysis? All right, I think Tyler, you're next. Or is it Audrey? I can't remember.
Okay.
Are you next?
Let me just.
Yeah, please.
I'm hung up on this. It's the way that you structured this class that gives us this lens. Harlan says this court, in its opinion, reserves the question whether Congress, in the exercise of its power to regulate commerce amongst the several states, might or might not pass a law regulating rights and public conveyances passing from one state to another.
Mm-hmm.
I beg to suggest that precise question was substantially presented here in only one of the cases relating to railroads. Robinson might be Memphis.
Mm-hmm.
It says commerce between the states notwithstanding. I mean, I think he says it before part of America and Atlanta. Part of Atlanta. I mean, is that not verbatim what they get to pretty much in the Heart of Atlanta decision?
Well, let me put it this way, right? Even if the court entertained that a railroad could be regulated because it's interstate commerce, right? The other accommodations couldn't. So the people who were indicted, their indictments were dismissed. And the court later came back in Plessy and said, this law was struck down, so we're not even going to think about it. But it was sort of, lazy is the wrong word, they sort of glossed over the fact.
I mean, I think it was pretty, knowing that we've started there and worked worked our way here. Like, it seems pretty brilliant, and nobody even responded.
Well, because commerce, this wasn't what commerce was. Commerce was exchange, intercourse between the states, and this wasn't that. Now, the question is, why didn't the prosecutors indict railroad operators? Right? Why didn't the prosecutors indict ferry operators going between states? That would, I think, a very different case. And I don't know the answers. I think it's a very good question you raised. I have to think about that more. But had they indicted an interstate railroad operator, that case may have come out a little bit differently.
And that's I mean, to be honest, I had a hard time reading the Memphis Railroad opinion.
I've never read it.
It's difficult language. But
What year was that case?
Sir?
What year was that case?
That was Robinson v. Memphis and Charleston Railroad, 1881. It was one of the 5.
I've never read it. I'll take your word for it.
I couldn't get the point, but the point was they were traveling amongst the states, and one of the passengers, African American, had a ticket, thereby interstate commerce. And I was surprised that nobody latched on to Justice Harlan's blatant, pointing out what eventually would be the basis for.
I've done a lot of work on Justice Harlan. I think I may mention this, but he was actually a ConLaw professor. Imagine this. While he was sitting in the Supreme Court, he taught an evening ConLaw class, I guess much like this one at the George Washington Law School. And he actually had one of his students who transcribes lecture notes verbatim. And one of my earlier papers, I had those papers typed up so you can read the entire thing straight through. And Harlan was very prophetic, where he often saw things people didn't see. And he often saw where the law was headed. And one of his comments in his lecture was basically saying, the future federal power will be about the Commerce Clause. And he saw how the rise of industrialization would necessitate Congress looking to the commerce power. So I think you're onto something. Harlan understood implicitly that the law was headed towards a collection of power under Congress's Commerce Clause authority. And he sort of maybe was hinting at it here.
So we didn't even get to the commerce stuff until that was 1964. It was Heart of Atlanta and here where.
Well, think about his opinion in Champion v. Ames, the lottery case, right? Where he discusses the movement of lottery tickets as commerce. He was getting at that much earlier. He was very ahead of his time. He was a remarkable guy. And his dissents in both civil rights cases and in Plessy stand alone as the only person willing to call out this sort of slavery, or what he thinks is basically a badge of slavery. We'll get there in a minute.
Yeah, I mean.
Very, very important judge. The reason why we still talk about him, right? His dissent in Lochner, his dissent in Plessy, his dissent in civil rights cases, right? His dissent in E.C. Knight, which is not nearly as sexy, but still, his dissent in E.C. Knight basically predicted the New Deal cases, right? It's about necessary and proper clause. Did Congress have the implied power to regulate local activity that burdened interstate commerce, right? His dissent in E.C. Knight foreshadowed, NLRB versus Jones and Laughlin Steel. Right? He was decades of his time. All right, so let's move to the 13th Amendment. Right? The 14th Amendment has a state action problem, right? Where it only applies to state actors. The 13th Amendment doesn't. It applies to slavery anywhere. But then the case turns on what exactly is slavery. And here, the majority of the dissent more or less agree on the right test. They agree that Congress has the power to enact laws to abolish the badges and incidents of slavery. It's not just actual chattel slavery. They can ban the badges and incidents of slavery. Lindsay, what are badges and incidents of slavery? Or at least, how does the majority understand badges and instances of slavery?
The institution and reminders, so the reminders of slavery, like separate instances. And
Well, how does the majority construe badges and instances of slavery? Or let me ask the question differently. Does the majority think that segregated accommodations are badges of slavery?
No,
Good.
they do not.
They do not. That's right. Why not?
They stated that when the 13th Amendment abolished slavery, this put them on the same level as the rest of the citizens, and that essentially their rights were protected the ordinary modes as other men's rights at that point.
Very good. Okay, the majority says mere discrimination on the basis of race is not a badge of slavery. In fact, they note that even before the 13th Amendment was ratified, many northern states had black codes, which restricted freedmen from basically entering places of accommodation. Okay? So here the court narrowly reads the phrase slavery or badges of slavery. Justice Harlan had a different account of slavery, right? Chelsea, how did Justice Harlan envision slavery?
He said things that were kind of like reminders or would differentiate
Yeah.
them to remind them of slavery.
Very good. Justice Harlan would say that the badge of slavery were basically signs of inferiority, right? Laws that treat black people as if they were still a second-class race. And specifically when they're being denied civil rights that the freemen enjoy. So being denied entry into a facility is a reminder that you are still not equal. And the majority has a very different conception than the dissent does of how this law works. The majority says, okay, we've enacted these laws, these amendments, that's enough, move on, carry on. And Harlan views it differently, right? How do you take a race that was long enslaved and bring to the rank of citizen? This doesn't happen right away. It can take time. And this sort of legislation is designed to help advance that cause. Later in the reading, when we cover affirmative action, there's a quote from Lyndon B. Johnson, who gave a commencement address at Howard University, where he gave this analogy. Imagine, you're going to run a race, and there are two people in the race, and one person in the race gets a 20-yard head start, and then they bang you in the knee and let you start running, right? Is that going to be a fair race? And Harlan has a similar envision. He's like, after centuries of bondage in this country, this legislation is designed to allow these people to actually take the rank of citizens, to actually enforce access to common carriers. So Harlan would define a violation of both the 13th and the 14th Amendments. Majority wouldn't. And the majority is still good law. The state action requirement is very stringent. It's still enforced today. And it prevents private actors from even being sued for violating the Constitution. As a practical matter, it doesn't really matter. We have the Civil Rights Act of '64, which Congress bases on its commerce powers, and allows the federal government to prohibit all manner of segregation and various accommodations. So it took Congress another 90-odd years to get back to where they started from. Right? They have the Civil Rights Act of '75, the Supreme Court declared it unconstitutional, and then in '64 they enacted another one which accomplished very similar things. So more or less you got back where you started with 100 years in between. All right, questions on civil rights cases? Okay, let's go to the next topic. The next topic concerns the Equal Protection Clause of the 14th Amendment. And we have two cases, I'm sorry. We have Yickwo and we have Plessy. And the contrast of these cases often gives students difficulty. It's like, how could it be that in 1886 you have this case which provides the rights of for Chinese Americans, and then you have Plessy, not even a decade later, which basically says separate but equals fine. Like, how do you reconcile these cases? And often students have a difficulty. Some people say, well, that's because they hate black people more than they hate Asian people. Maybe that's the case, or maybe there's another reason why these cases turn out differently. We also have Justice Harlan, whose dissent always surprised people. It's like, whoa, where'd that come from, right? Whoa, it's like, oh, I thought you were cool. Now you, anyway. So no one is woke enough by modern standards to even survive. No one is. So I think you always have to take people based on their historical records in entirety. You can't. It's hard to judge people by today's standards when they lived a long time ago. But the Harlan thing always people jump out at. Okay, who's next? I forgot. You next? Okay, sure. I love that you're also active. If you were a quiet student, it would be painful for me. I would just lecture. I was actually afraid that I have to just lecture for 2 hours straight, but this has worked out quite well. Audrey, you want to give me the facts, please, in Yiquo?
Sure. So Yiquo was a laundry owner.
His name was Lee Yick, but yeah, Yiquo is fine.
He was a laundry owner, and he was Chinese.
Mm-hmm.
And then San Francisco passed a law that made all of the laundry owners and laundry buildings that were made out of, or that weren't made out of brick or stone, that you had to, in order to keep continuing their business, they had to get some type of license.
Good.
So
Well, tell me about what was the license? What kind of license was this?
I think it was kind of like a permit to, I don't remember.
What did you have to do to get the permit? South Texas College Law is calling me. No, I'm in class. What did you have to do to get the permit?
You had to go through somebody because theirs got denied.
Oh, it got denied, but what
You had to go through,
but what did you have to do to get the permit? What were the steps?
I don't know.
Tyler?
It was based on the building's construct, right? It was for brick buildings as opposed to.
Okay, so if you had a wood building, you need to get a permit, right?
Correct.
If you had a wood building, how would you get your permit approved? What would you have to show? No, if you were a wood building, some people got permits, some people didn't. How did you get your permit approved? What did you have to demonstrate? Is he?
You didn't have to do anything. It was an arbitrary standard.
What does it mean to be arbitrary standard? What does that mean?
The person who was giving you the permit could decide for any reason or no reason at all to give you the permit or not.
Bingo.
So they don't do an inspection?
No inspection.
Oh.
Right, so you think of like a safety permit, they come in, make sure you have smoke detectors, right? Make sure you have ventilation, make sure that, you don't have any fire hazards. There was no standard at all. It's you apply for the permit, and maybe it was granted, maybe it was not granted. It was based entirely on the discretion of the government. There was no standard on which you could be judged. Not like say, okay, I'll make my facility safer. Once your permit was denied, that was it. Now we know that Lee Yick had his facility in operation for nearly 2 decades, right? He'd been doing this for a long time. And his facility had been approved only a couple years earlier, but they came around and denied it. Now, Chelsea, let me ask you this question. Was there any written policy that says oh, I just got an email from the registrar. We don't have anything for you for your midterms. No, they're wrong. Oh, they can't do the midterm things. I know I did this one right. ConLaw. Okay. I totally. All right, whatever. Okay. Just use Word tomorrow. I think it'll be easier. Make it easier for me. Okay. I forgot where I was. Okay. Yeah. So the permit can be denied for any reason, no reason at all. Oh yeah. So Chelsea, let me ask this question. I had to play back the last 30 seconds. Is there any statute or ordinance on the book that said we're going to deny all licenses to Chinese people, but everyone else gets them? Is there any like statute written down that said that? No. Instead, we know as a practical matter who got the permits denied, who got them granted, right? That all the Chinese people got the permits taken away, and basically everyone else got the permit granted. This was a criminal case. Basically, Li Yik was not given a license, and he was assessed a fine. He refused to pay his fine. He was arrested. Okay. This was a well-financed case. Most poor Chinese launderers don't have the money to appeal their case to the Supreme Court, right? This was a case actually backed by the Chinese government and various Chinese benevolent associations to help their own people. And there were several cases where they wanted to get the Supreme Court to acknowledge that their people were being discriminated against. So it was actually a criminal case. He was arrested and jailed for failing to pay the fine. Hopkins, I think, was the sheriff of the town. Now, what's the argument, right? Audrey, what was Yik's argument that this law, and actually the prosecution, was unconstitutional?
Didn't they say that, I mean, obviously the Equal Protection Clause of the 14th Amendment, but it was discriminatory because the fines were only placed within his race, even though it was a neutral law, like the law didn't specifically say anything about Chinese or whites or anything like that, but then in San Francisco the only laws were, or it was only specifically towards his race. That's what I thought.
Okay, very good. Oh, I see what happened. I see what I did. I screwed up. No, I screwed up. I only submitted the exam number thing for the final exam, not for the midterm. Oh, so this is my screw up. Okay, I'm sorry. All right, so just use Word. I think it'll be okay. There's only 5 of you, or 4 of you here. Okay, very good, Audrey. Thank you so much. So the argument was that this law violated his rights. Now, most books view this as an equal protection case. I'm somewhat of an outlier in this. I think the case is different. And I only reached this conclusion. I did a thing on C-SPAN last year on Book TV, where they have a, like a 1-hour live TV show on Yik Wo. And I did a lot of thinking about the case. And the case is actually involving what we sometimes call the right of contract, that they were arbitrarily depriving his right to earn an honest living. Now, we know from Slaughterhouse that that's not a privilege or immunity of citizenship, right? That the right of the butchers to run their business was not protected by the Privileges or Immunities Clause. But he was being deprived of a right of property, that his business to run a laundromat. So I think this case is often mischaracterized. I think it's actually a due process case. And if you look at the what's called a companion case, which was another one of the cases decided by a federal court of appeals, they were talking about regulating the business and depriving him of his business and livelihood and his property without due process of law. So I think this case is actually best viewed as a due process case, but also as equal protection, right? Because the law is not being enforced in an equal-handed manner. And this gave rise to a very famous test that the court advanced, right? He says, though the law be fair in its face and impartial in appearance, yet if it is applied and administered by public authority with an evil eye and unequal hand, so as practically to make unjust and illegal discriminations between persons in similar circumstances, the denial of equal justice is still within the prohibition of the Constitution. And this test is very famous because it teaches a different lesson, right? What happens when the government comes to court and says we're doing this for reason X, and it's so painfully obvious that it's not the real reason? That the real reason is Y. What do you do? At that point, the court would say, well, we limit our review to the face of the statute and no more. Think of like Korematsu, right, in the Japanese detention cases. Oh, by the way, you guys following this concentration camp debate?
Yeah.
You're thinking about Korematsu, right? Yes.
Yeah,
Perfect timing, right? Justice Jackson used concentration camp. I think Justice Murphy did as well. Oh, no, Justice Roberts did. But Justice Black said they're not really concentration camps in the majority. So even then, they were disputing this. But how does the court handle this, right? And who is a court to say that this other purpose is improper, right? How has the court to decide that some other purpose is improper? The argument isn't that the state lacks the police power. It's not a structural argument. It's an argument that we've decided as judges it's an improper purpose. Now, I think we can all agree that it's a very bad idea and quite racist to exclude Chinese people from their businesses. But why is that an improper purpose? And the court's never really pinned this point down, but it's basically the judges saying, we think it's a bad idea. We think it's unwise to do this. And indeed, judges do second guess the wisdom of legislation. We think this is a bad idea. But in any event, based on both due process and equal protection, the court finds that the prosecution is unconstitutional. Right? The government's mind was so unequal and oppressive as to amount to a practical denial by the state of the equal protection of the laws. And yet a facially neutral law, the law said nothing about Chinese on its face, but was enforced in unequal fashion. The only justification is the improper one, hostility to the race and nationality. Therefore, the discrimination is illegal. It was based on other motives, in this case, animus towards Chinese people. Okay.
How did you get on C-SPAN?
They called me?
Really?
Yeah.
Oh, casual. Yeah.
I don't know how people find me. I don't know. They have calls all the time. Twitter helps. It was weird. You can watch. I think I put it on my YouTube, but all these people calling with these crazy ass questions. It's bizarre. It's like, thank you, caller. Right. Next. Some of the questions were crazy. I was on it. There was another professor from Columbia who actually studies Asian American studies. She wasn't a lawyer. I don't think she was, at least. And I was a lawyer. But it was a good show.
I watched the first, I think, 40 minutes of it so far.
On Kormat? On Yikwo?
Mm-hmm.
Oh, good. You actually watched it?
Yeah, some of it.
Wow. Well, I'm impressed. Well, look okay?
Yeah, I couldn't hear some of what the callers were saying, but I remember at one point you were like, let me take out my pocket constitution.
That's something I would say. I don't remember that, but I'm sure I did say that. It's come in handy so many times in my life. I remember when I was a summer associate after my second year of law school, I was working at a firm for a summer, and we had this like intake form, like list your interests, right? So of course I list the Constitution, we were at some cocktail hour, and one of the partners was making fun of me. He's like, "Oh, so you like constitutional law?" I'm like, "Yeah." He's like, "ConLaw has nothing to do with what we do here at the firm." I'm like, "Oh, really?" So whip out the Constitution, go to Article 1, Section 8, the Appropriations Clause. So he's a government contract lawyer, and all of his work's with government contracts. I'm like, see, Article 1, Section 8, Appropriations for 2 years. And he gave me this look like, what? Who are you? And I realized at that point I shouldn't work at a law firm. That was not for me. But it comes in handy. It sells a lot of bar bets and stuff. Not really, but I like it. It's a good prop, if nothing else. I've taken it out for a dramatic effect in various occasions. Okay, so that's Yikwo. And again, Yikwo is sort of a weird case because you have all these other decisions that are so restrictive of the 14th Amendment, yet Yikwo actually has a flavor that the courts can prevent this sort of racial discrimination. Yikwo is still to this day cited. Parties still cite Yikwo over and over again. It's it comes up quite a bit. The next case is one that you're not supposed to cite, the Ante-Canon case of Plessy. Yeah, I think I mentioned this yesterday, but Justice Gorsuch had an opinion earlier this week where he said, well, if we suck with stare decisis, we still have Dred Scott, Korematsu, and Plessy, and not really, because Dred Scott was killed by the 14th Amendment, and Plessy, I think, was mostly overruled by Brown, and Korematsu was overruled in the court of history. But when you say Plessy, people just know this case as evil. But think about it. Everyone knows Tawney, right? People know Chief Justice Tawney. No one knows Justice Brown, right? Henry Brown. Anyone ever heard his name? He was the guy who wrote Plessy. No one knows his name. And why is it that Dred Scott has just taken on this singular importance, but these other equally odious decisions, like who wrote Crookshank? My goodness, that was a god awful decision, right? That was a bad decision. I don't remember the guy who wrote. Was it Miller? I think it was Miller. But no one knows who these people are. Anyway, all right, let's do Plessy. I'll do the facts. Actually, no. Who? Oh, by the way, Chelsea, how'd you even find the video on YouTube? How'd you come across it?
Oh, I was Googling today what happened at the end of
Yeah.
to see if he had ever gotten a permit, and
Oh,
the video popped up, and so I listened to it, but I'm only like 35 minutes.
It's amazing how people find my stuff on YouTube. It's stunning. I only have like 2,500 subscribers, but I get people watching my stuff. Like the organic search is very good. We're gonna have so much more content with these videos when they finally go online. Okay, so yeah, Audrey, want to give me the facts, please, on Plessy?
Oh, yeah. So Plessy, this was the railway case where there was the separate railway cars for Caucasians and African American blacks. And then, so Plessy, he was actually not completely 100% African American. He was actually only like 7/8.
Yeah, and let me just pause here. We don't have any photographs of Plessy. If you Google him, this drives me nuts. If you Google him, there's some websites that say that this is actually the guy. We had a person present a paper from another school this semester. Who was it? I can't remember who it was, but someone came to South Texas and was doing a PowerPoint to the faculty. And he was doing a PowerPoint. Oh, no, no, it was a she. She was giving a PowerPoint, and she put up a slide on Homer Plessy, and had this photograph of someone who wasn't Homer Plessy. And like, I actually raised my hand. I'm like, that's not Plessy. And it wasn't the Louisiana governor, it was someone from Louisiana. I couldn't remember who it was, but if you just Google him, there's some picture. It's not him. So we don't actually know what he looks like. We have no idea. But the court describes him of mixed descent. So he was, biracial.
What is it called when someone purposely breaks the law in order to...
Okay, so the race is test case,
Yes,
right?
this
And
is a test case.
it's a test case. And what does that mean? Homer Plessy was deliberately arrested, right? He knew he was going to get arrested. And he wanted to get arrested to inject this case into the legislature. I'm sorry, to inject this case to the judiciary. And the hope was to get the courts to rule that this Jim Crow law was unconstitutional. It didn't work. But having it was a test case, right after his arrest, he was post bond $500, right? That's a lot of money back then. That's a huge sum for a guy to have. And he had very competent counsel. And by the way, who's Ferguson? This is some weird. Ferguson's the judge. And this is some weird Louisiana stuff. I've looked into it, and at one point I knew the answer, and actually I can't remember it right now. But the short answer is, in Louisiana, when you challenge your sentence, you actually have to sue the judge who sentenced you. It's sort of a weird thing, right? I don't fully understand it, but Ferguson was a judge. The same, in a similar respect, Hopkins was the sheriff. Here they're suing the judge. It's sort of backwards. All right. Well, we know the outcome, right? The vote was 8-1, and the court ruled that the statute was constitutional, right? So first off, I think Audrey, you're next. I can't remember with so few people. Are you up next?
I like this case a lot.
Oh, no, I just called you. Give me the facts, right? So Tyler, you're next. Okay, Tyler, so the first part of the opinion is about the 13th Amendment, right?
Right.
Did the segregation law impose sort of a badge of servitude between the races? He did. And what about the majority?
They didn't see it that way. They were actually kind of, I don't know what the word is, terse, short.
Oh yeah, they had terse is a good word. They sort of blow this argument off really quick. And they basically say merely separating the races doesn't mark you the badge of inferiority. And if you feel inferior, because you choose to have it, right? The majority is basically blaming Homer Plessy for feeling inferior. Which, I mean, it's a stunning argument to say it out loud, right? That if you feel that segregation is making you inferior, that's on you, right? Suck it up. Don't be such a wuss. There's no badge of inferiority. But this holding, I think, follows from the civil rights cases, right? I think if civil rights cases was the precedent, this construction of 13th Amendment controls. But the far more famous aspect of this is the 14th Amendment. The court holds that separating people based on race is within the state's police power. And this was a reasonable exercise of the police power. Why was it reasonable? Because there's a long tradition of segregation. And that this is essential for promoting the public peace and good order. And then Justice Brown adds that the 14th Amendment was never intended to abolish distinctions based on race. That the races can't be forced to commingle with each other. It's always struck me bizarre. The races couldn't commingle, that the train company was required to segregate, right? It wasn't the train company said we want to do this on our own. It was the state mandated the separation. And then Justice Brown explains that we have history to explain this, to teach us, right? We know that at the time the 14th Amendment was ratified, public schools in the District of Columbia were segregated. And if the people who ratified the 14th Amendment thought you could segregate public schools, then we should not read the 14th Amendment to teach otherwise for railroads. We will come back to this history when we do Brown v. Board. Because one of the arguments in Brown was, well, if the framers of the 14th Amendment were okay with segregation, then the 14th Amendment doesn't prohibit it. We'll come back to the argument later. All right, any arguments in the Plessy majority? I mean, the famous rule is separate but equal, right? It's stated very bluntly, tersely. I think I like your word, Tyler. It's almost like they didn't recognize the extent of what they were saying. So, yeah, of course, this is so obvious. But this decision basically opened the door to Jim Crow segregation nationwide. All right, questions in the majority. All right, let's go into the dissent, right? Again, we have a lone dissent from Justice Harlan. And he, again, found the law was a badge of servitude. Right? For the same reason that the segregation in the civil rights cases was servitude, here too we have a badge of servitude. But we don't need the 13th Amendment because there is state action. There is state action because the 14th Amendment applies to state action. This was a Louisiana law. And he has a very famous passage. He says, our Constitution is colorblind and neither knows nor tolerates classes among citizens. There is no superior, dominant ruling class of citizens. All citizens are equal before the law. Now, this is you love it, like, yeah, go Harlan, right? But some people don't like this quote today because in many regards, some people argue that the way to eradicate inequality is to openly consider race. That is affirmative action, other sort of race-conscious measures. Chief Justice Roberts had a very famous line in opinion. He said, the way to end discrimination on the basis of race is to end discrimination on the basis of race. And then Justice Sotomayor replied, I forget the exact wording, but she said something like, well, the way to end discrimination on the basis of race is to understand or take account of discrimination on the basis of race, right? And so they vigorously disagree on how you end racial discrimination. So the Harlan approach sounds great, but isn't so popular today among some groups. So questions on Plessy. Plessy today is often put in the same sentence as Dred Scott and Korematsu. Justice Gorsuch just did that the other day. And one of the reasons why Plessy is so effective is virtually everyone thinks it screwed up the 14th Amendment, right? Even if you accept the civil rights cases, right? Let's say you accept civil rights cases, no state action. Here there's state action. There's state action. And the state is basically forcing the law to be applied differently to different people on the basis of race. It's hard to square Plessy with any reading of the 14th Amendment. Yet, not even 3 decades after it was ratified, the court basically gutted it. So let's walk through our cases, right? We have Slaughterhouse, which gutted the Privileges or Immunities Clause. We have Bradwell, gutted Privileges and Immunities. We have Cruikshank, prevented the extension of the Bill of Rights to the states. Then we have the civil rights cases, which basically neuter the Section 5 powers. And we have Plessy, which allowed separate but equal to go forward. So think about it. Section 5 is dead. Equal Protection Clause is dead. Privileged Immunities Clause is dead. What's the only provision of the Bill of Rights, the 14th Amendment they didn't touch? What's the only one left? It's the Due Process Clause. It's the only one they didn't touch. So what you'll find, starting class for next week, on Monday, we begin the Due Process Clause. It was the only provision of the Constitution, the 14th Amendment, that wasn't gutted during this period. And that's invariably where the court turns to start scrutinizing laws enacted by the government, right? One of the reasons why there's so much focus on the Due Process Clause today is precisely because the civil rights cases and Slaughterhouse and Plessy weakened the other provisions, right? Our modern due process law is a direct byproduct of the case from the 1870s, 80s, and 90s, right? We are where we are today because of what happened during Reconstruction. I'm sorry?
Everything makes sense.
Oh, God, I hope it does. I don't, it does make sense to me, but hopefully it clarifies a little bit. All right, so questions on Plessy. All right, again, so for the midterm tomorrow, just type it in Word and email it to me. Just tell Tim we can get the exam numbers. I mean, it's 4 of you. It's not going to kill you. And it doesn't count for your grade, so the anonymity is not as important. Again, it's 1,000 per question, not 1,000 total. There are 2 questions. No, I'm sorry. For the midterms, only 1 question. Midterm is 1 question and 1,000 words. You have 90 minutes for it. Don't take the full 2 hours. You have 90 minutes. And just when you're done, email me the Word document, and I will be happy to go over it with each and every one of you. It's only 4 of you. I think it'll be easy enough to do. All right. By now, you should have at least taken some of my old exams. They're all online. You can bring whatever you want. Don't Google. Please don't look on your computer at the internet stuff. It will only hurt you. I can't lock down your laptops, but I'll have you on the honor system. There are so few of you. All right. Anything else? All right. I will not see you tomorrow. I will be in Utah. We'll be talking about religious liberty at BYU. I will see you next week. Thank you.